Okay, so this video is for the legal system and method, um, and the topic is rules of statutory interpretation. So I was asked to make a general answer structure or a general outline for the rules of statutory interpretation. So this is the general outline. We'll first go through some of the past paper questions, and then accordingly, then we'll just dive into the general structure. So the structure is going to have the simple, literal, golden, and mischief and purposive approach. It's just going to tell you what they are. It's not going to focus on any of the specifics of the questions, because of course sometimes there are questions who ask focusing on literal approach or focusing on the purposive approach, that how the purposive approach has changed, throughout years, and how, and does it help or doesn't it not help. Question like those need more analysis, more case law, more discussion on those particular topics. In this question, this is just gonna be a outline, but I just want to go through with it, that what type of questions would pinpoint the outline, right? So the question is, the advantages of the literal rule are that it restricts the judges to applying the law and recognize that only Parliament makes law. Describe the rules of statutory interpretation, and discuss how the different approach to statutory interpretation gives greater or lesser respect to the idea of that only Parliament makes laws. So here it talks about literal rule. Of course, you will tell that there is a golden rule, a mischief rule, or a purposive approach. But at the end of the day, this question C now talks mostly and only about literal rule, and how the idea is that Parliament makes laws. So how literal rule literally says that, okay, whatever the Parliament says, it is what we're going to enact. So you need to focus a lot on literal rule rather than the other ones. So this is not a general question per se. The other one is, explain why the interpretation of statutes is often difficult, and discuss which rule or approach to statutory interpretation produces the best outcome. Now, this question, okay, so the numbers with these questions are 6, 10, or whatever. So I took them out from the past papers. So I think it was 2018, 2019, 2017, and so on and so forth. So now this question, it is a very general question, right? It is a very general question. But what at the end it talks about is that okay, so explain why the interpretation of statute is often difficult. So of course, first explaining why the interpretation of statute is difficult, and then discuss which rule or approach to statutory interpretation produces the best outcome. So here first you'll tell that why is it difficult, then you'll actually talk about what rule or approach you think is appropriate to produce like the best outcome. Now you can there are two different things in this question. So of course this does talk about you telling every single rule and every single approach, and then making your own judgment out of it. The other one is, the interpretation of statutes is a craft as much as a science, and judges as skilled workers select and apply the appropriate rules as a tool of their trade. Describe the rules of statutory interpretation and explain how and why judges use these rules. Again, this talks about the idea of, okay, so this question focused more on what how is interpretation of statutes difficult, and what you think is the best producing outcome, right? What interpretation produces the best outcome. Here it talks about how judges as skilled workers, you know, interpret statutes, or how the interpretation of statutes is through judges, right? um, and then you talk about all the rules and approach, and then explain how and why judges use. Now here you mainly talk about explain how and why judges use these rules. So of course they use it for interpretation. They want to figure out what parliament's intent was, and how to give best meaning to whatever word is there. So all of that jazz, right? Okay, so there is a paragraph to this as well. The paragraph is judicial approaches to statutory interpretation have changed over centuries. This is because judges have, at different times, had more respect for the legislative supremacy of Parliament. Describe the rules of statutory interpretation and explain the extent to which these approaches can be said to value the legislative supremacy of Parliament. Again, you will talk about all the rules and approach. Nevertheless, you will over here as well talk about judicial approaches to statutory interpretation, how judges see law, right? And then the first question we talked about the parliament and how legislative supremacy is upheld or is it not, or what happens through what statute, through what interpretation, I'm sorry. So with literal rule you might say that it's exactly what the judge has, like what the parliament has written, but again with mischief or golden you might say, okay, sometimes the legislators even put ambiguous words to you know give the judge a discretion of wider interpretation. So you'll read more, you'll understand, and then you'll write how you see fit. Now this is the last one, and that's it. There are no strict rules for statutory interpretation of statutory interpretation, only different approaches depending on the inclination of the judge. Okay, so yeah, this is all the rules, and then you talk about how the judge sees and makes interpretation. How does he interpret law? So, what is statutory interpretation? Now, a very simple question. Um, if you break it down, it's like a statute and interpretation. So here is where the court judges look for the intention of Parliament to act to apply acts of Parliament which have has been enacted by the Parliament. So the judiciary's role is to apply laws made by Parliament, right? But in terms of what if a very very simple point is what is statutory interpretation? It is interpreting what the statute says in accordance, in line with the intent of the parliament and the case law that the judge is deciding. That's what statutory interpretation is. Okay. Okay, I feel like this is good, so I just kept this quote because a lot of people do write quotes in their answers. And yes, not every single time you need to like copy paste lengthy, long quotes, but sometimes if there is like an essay and which this is. So with good essays, maybe if you feel like at the start of the essay you could write this quote. So this is good. This is Lord Stein. The language used by Parliament does not interpret itself. Somebody must interpret and apply it. A democracy may and almost invariably does entrust the task of interpretation to the neutral decision making of judiciary. Talks about judiciary, talks about parliament, so I felt like this is a good quote. Okay. So, okay, I've just noted down some points as well for statutory interpretation, like a complicated process because of ambiguity of certain words used in the statute, inadequacy of language, the imperfection of language. When you're talking about like what are the problems faced in statutory interpretation, so these are the things you can write. So that's the reason I've just mentioned some of them. The degree of precision and comprehension over what could be known as the Parliament's intent, like Parliament's intention. So sometimes draftsmen deliberately leave ambiguity in provisions in order to enable courts to tailor them to future situations that cannot yet be anticipated. That's exactly what I was talking about. See, so there are times when one word could be stretched as a, uh, you know, That is vehicle. I think that's one example that we have read about so many times. It's the idea that vehicle used to be just a car, but today, you know, a truck could be a vehicle, a cycle could be a vehicle, or could it not. Now, these are, of course, ambiguous areas, but at the end of the day, it has like the cycle has two tires and two wheels, and so um, there is a bit of room left for you to interpret or for the judge to interpret, right? Um, okay, so it is notable that the general methods of statutory interpretations are not themselves regulated by Parliament, but have been developed by the judges, which is very true. So, because there is no statute saying that, oh, there's this literal rule, or there's this golden rule, or there's this like mischief rule, and there is no statute saying that. So these are rules that the judges have decided and developed on their own throughout years of case law. Three so-called rules of statutory interpretation has been identified as Mr. Golden Ritual. So, okay, these three rules are there, but there is an approach that they keep on mentioning in the questions as well, and the approach is the purposive approach. All right. Um, it's also the teleological approach, which the European countries, the European Union, used to focus on and focuses on. So, and there are those questions which actually precisely talk about the modern rules of interpretation, and they talk about how the development of European countries and European rules or approach has, credited to how the UK see the interpretation. So that I am not going to be discussing at all. And I will also not be talking about HRA and Section 3 or on any of those. I'll just be going through the rules in this one. So I've noted down as like points over here challenges in statutory interpretation. The first is drafting printing errors. Second is new developments that render statutes outdated. Third is challenge in use of language. Four is broad, ambiguous terms. Due to this, judges often try to analyze and interpret the meaning of words. So this gives judges leeway, but one may say that, okay, maybe that was not the parliament's intent. Now, this is a play of words. You can take it this way or that way, right? And let's start with literal rule. That's the first one. So the literal approach is dominant in the English legal system. Courts took an extremely strict view of the words of a statute. If the case before them was not precisely covered, they were not prepared to counter any alteration of the statutory language. Okay, I okay, I'll explain this in this way that if anything, if the parliament has written um, whatever, no to something, right? So the literal rule does not give you a space. Like there is no space to consider when applying this rule. If it is a no, it's a no. It will not talk about maybe. Like there is going to be black or white. It does not talk about gray, which is thought to be rigid in interpretation. And as I think you might have understood by now, that rigidity in interpretation or rigidity in law is not really welcomed, because the law has to evolve, the law has to keep itself up to date with the society, the law has to keep on changing, it has to be, moving forward, it cannot be stagnant. So, okay, we have cases as well. So we'll see the case of R versus the Judge of City London Court, 1892. Lord Esher, Master of Rules, stated that the literal words of a statute are to be applied, even if they lead to a manifest absurdity. Court cannot question whether the legislature has committed an absurdity. See, this is how strict the rule is. Um, Now it is for you to, put this in your answers. Do you agree with it or do you not agree with it? Or how do you see this words to be? Again, more is that under this rule, the courts appear to be recognizing their limitations, right, by following wishes of the parliament as expressed in words of legislation. However, there are many difficulties in assigning a fixed meaning to a word as well. In R versus Harris, R against Harris, defendant bit off the nose of the victim. Their conviction was quashed using literal interpretation to words unlawfully stabbing, cut, and wounding any person. The courts required a form of instrument used. Teeth were not considered a weapon. So, which is wrong. I mean, that in that situation, hands cannot be a weapon or a tool as well. Because if I strangle someone and if I kill someone by strangulation, I might be charged like under murder, sure, but like if I hurt someone under the like if I'm not killing someone, but like just hurting someone by strangling them. So apparently, this would be like, oh, through the literal interpretation, I have not stabbed someone or cut someone or wounded anyone. So, that's a very odd. While the definition of like wounding is in criminal law, it is the cutting of two skin, the upper dermis and the lower dermis, but like okay, so the person was, the conviction was quashed. So there's a absurdity in the judgment, but it's the literal rule has been applied. Then we have the Chapel 1868, a person charged with impersonating any person entitled to vote at an election was acquitted because the person impersonated was deceased and thus not entitled to vote. These cases illustrate the major criticism of the literal rule, and it emphasizes on adherence to the literal interpretation of statutes results in absurd outcomes not intended by Parliament. So I'm pretty sure the Parliament was not thinking, oh, it's okay. Let these people off because so I'm pretty sure the parliament wasn't sitting there and being like, oh, it's okay, people getting hurt and but letting other people off. So it will make no sense because statutes are there to protect the people, right? So it wouldn't genuinely make sense if the parliament's intention was, oh, letting people off, even if you bit off somebody's nose and then, you impersonated someone. So well, the advantage and the disadvantage, I'm just like reading this out because I wrote it down. So this falls in line with the separation of powers. Parliament's will is enforced as close to how it was written. The law is more certain it will be applied exactly how it is written. So it is clear for people to anticipate how it will be applied and what their obligations are. The disadvantage is a literal approach can lead to an unfair outcome. Statutes may not be drafted properly and perfectly. Two things. The drafting may not end up reflecting the intention or purpose of the statute. Example is the Chapel case, right? And then, however, words may also have more than one meaning. Courts will have to decide which meaning makes the most sense given a certain set of circumstances. Now, this is something that, it's a case to case thing. Let's talk about the golden rule. Okay, so of course, this is not the literal rule, this is a golden rule. This rule is generally considered to be an extension of the literal rule that was set out by Lord Wensdale in Pearson 1857, right? So, okay, so in that case, what he said is the grammatical and ordinary sense of the word is to be followed unless it would lead to absurdity or some repugnance or inconsistency with the rest of the instrument, in which case the grammatical and ordinary sense of the word may be modified so as to avoid the absurdity and inconsistency, but no further. If the literal rule leads to an absurdity, repugnance, or inconsistency, the judge can substitute a reasonable meaning in light of the statute as a whole. So the golden rule is an extension of the literal rule, and what it talks about is better than what Lord Escher talked about. So he was like, even if the answer is repugnant, even if the answer is absurd, right? It leads to an absurdity. It should be followed, right? Even if it manifests absurdity. Here, Lord Winsdale is like, no, if the grammatical and ordinary sense of the word leads to an absurdity and repugnance and inconsistency with the rest of the instrument, because of course the rest of the instrument has to be read as well. So if that is the case, you are not to follow it. So you are to modify it a bit so it can hold the correct and true intention and meaning. So it does not be an absurd or repugnant answer, but no further as well. So of course you have to, keep it in light with however much you can with the literal approach. But in golden approach and golden rule, okay, this is like the golden rule. So there are like a I have felt, and if you read further, which in several books, it has been mentioned and noted that there are two approaches to golden rule itself as well. So there is a narrow approach and there is a broader approach. So we'll talk about the narrow approach and then we'll talk about the broader approach as well. So the narrow is that this is used where there are two apparently contradictory meanings to a particular word used in a legislative provision, or the provision is simply ambiguous in effects. All right. So this is the case of Adler and George, 1964, where the phrase "in the vicinity of any prohibited place" included "in the prohibited place itself, the Air Force Station." Right? The defendant argued that he was not in the vicinity of the prohibited place, but in the prohibited place itself. Now, a very good idea is to think about how literal approach would answer this. So the funny part is if it said that in the vicinity of the prohibited place, but does not say in the prohibited place, right? So if the literal approach was used, it would say that, oh, the guy is in the prohibited place itself. So you can't really say that he has committed a crime, like he's committed, a problem here. Okay, so the literal rule would, mean that if the guy is not in the prohibited place, he's not committed a crime. So that he's done no wrong. That's what literally it means. But of course, because we're extending it with the golden rule, so a man was arrested for obstructing the forces in the vicinity. The court had a wider interpretation of the words "in the vicinity" in order to avoid an absurd interpretation. The court used a golden rule to extend the literal meaning of the word vicinity, which resulted in an offense, right? So the judges successfully demonstrated that the golden approach as a tool of interpretation in order to prevent an absurd outcome. Because if that were the case, then this guy would go scot free, like obstructing the majesty's forces. So that would have been wrong, right? Now, the broader approach over here is this version of the golden rule is resorted to where, although there is only one possible meaning to a provision, the court is of the opinion that to adopt such a literal interpretation will result in repugnance or absurdity, right? So for this, we have the case of Resegwet 1935. So here, a son has murdered his mother. all right, and stood to inherit as the next of kin, not kind, next of kin under the Administration of States Act 1925. 10 years ago, the act was there, so good. The court, however, used the golden rule to argue that the act did not allow an issue to inherit if he or she has killed the deceased. Now, okay, so the point, the entire the premise is, sorry, that the under the statute setting the law on so so under the law he was standing to inherit everything, right? But the thing is that he himself had committed the murder. So the absurd part over here would be, the repugnant result would be that he killed and he is standing to inherit everything, and he would inherit everything, right? So of course they had to. Now this is not even written in the statute, but they are going two steps ahead and saying, oh, even if it's not written in the statute, because he has committed a murder, because he has done a wrong, and because of that wrong, he is to inherit the estate. So that cannot be done, because of a wrong a person cannot benefit, so you cannot benefit by your own wrong. So with that nuance, they said that this is a repugnant result, and so he will be entitled with nothing. So that was an idea that you go two steps ahead and say that, oh well, you can't because you killed someone. That makes more sense, all right? Now, the advantage over here would be this helps to give judge a way out of using a literal rule. A judge can choose the most sensible course of action. That is genuinely in Reese Sigworth. I think even more than George and Butler, Reese Sigworth, because it was not actually written in the statute itself, right? So that gives you more room to work with. So, and the disadvantage can be that it can only be used in limited situations, can't predict when a court will use it. Which is very true, because, again, there is no statute saying that these are the golden rules and use them this way and in this case. Anyway, we move on to the mischief rule. So this requires the process of interpretation to consider the position of common law prior to the introduction of the statute, to try to identify the gap that was to be filled by the act. This gives judges far greater discretion than the above-mentioned rules. The definition of the rule is derived by the Hayden's case, 1584, whereby the following questions were asked, right? What was the common law before making out the act? What was the mischief and the defect for which the common law did not provide? What was the remedy Parliament introduced? The true reason of the remedy. We have this in Hayden's case in the mischief rule, right? These questions. But I feel like these questions should be asked in every single interpretation. Like, that is the reason the judges are to interpret, statutes. They need to see what the act was before, or what the common law was before, and what was the defect, the gap, the mischief that the common law did not provide. And that is the reason you're using this mischief rule. You're trying to, bridge a gap. Then what was the remedy that the parliament introduced, or how much the parliament introduced a remedy and left the discretion to the judges? Then the fourth is the true reason for the remedy. Like, exactly, why did the remedy have to come into place? Like, there has to be some wrong. That is the reason that there was this remedy, right? So that's the mischief rule. This rule tries to look at the spirit of the statute or the purpose behind the statute. It tries to see what mischief the act is trying to repress. Absolutely. So we have so at one level, the mischief rule is clearly the most flexible till now out of the literal golden even with its narrow and broad approach. We see mischief rule is clearly the most flexible rule of interpretation, but in its traditional expression, it is also limited by being restricted to using previous common law rules, right? So you have to see the previous, the first point was, so you have to see what was the common law before making of this act, of the act, right? So you have to see the previous common law as well. So there is this restriction, which I find that, okay, there would be, of course, some sort of restriction because there's always the idea, the nuance of judges not making law, or how much the judges are making law, or are the judges making law, or are the judges not making law. That there is an entire chapter talking about how judges are making law or how they're not making law, right? Or how they're just interpreting what the parliament's intent is and how they're not, how they're going a step forward. So and that question does arise. So I understand how this idea would limit it, the previous case law, the common law would limit it. And it is regarded as the oldest approach to interpretation because you can see it's 15, what is it in Hayden's case? It's 1584. Yeah. So it is one of the oldest approaches known of interpretation. So when judges were actually, this is the time when the judges were in control of the contents of statutes and parliament was not as powerful as it is today. So that is an important aspect to note as well, that in 15 hundreds, the judges were actually more powerful than the parliament. So judges could actually make law kind of at that point, right? So they could actually make law. Our first case over here is Smith and 1960, right? So this is the, I'm pretty sure everybody knows it. So this is the under Street Offences Act 1959. A prostitute could not solicit on the street or in a public place. The defendant was tapping on the window and calling out into the street. She was held to be on the street, as the purpose of the statute was to remove prostitution from the public space. Now, this is a fun interpretation. I feel like this is a fun interpretation, right? So the idea is that, okay, so I'll just actually, I have this in mind. So it was the loiter and solicit in the streets and public spaces for the purpose of prostitution. So that was not allowed, right? So the defendant argued that they were not in breach of the act, as they tapped on a house window, which is inside the house, right, to attract the attention of passers-by. So I I hope, and I don't know, I hope or not, but if you have seen old movies, or if you have seen I don't know, if you've read books, and I have, I'd say that here. You would read, or you'd see the scenario where women prostitutes, they're sitting inside the houses, but their windows are open, or yeah, their windows are open, and they're like waving small piece of cloth. Yeah, I'm pretty sure this is like old movies or something. I don't know where I got this idea. I have seen it, but I don't remember. I can't pinpoint where, or I've read it. And that's like a thing. It used to happen. And similarly, they can tap on the windows to like attract the attention of the passerbys, saying that if they wish for the services. Now, in in their defense, they're not on the street and they're not on the public, but they are attracting the attention of the public, and they are kind of on the street, but they're not on the street. So this is a very, see, this is what I'm talking about. This is a mischief rule. They're not on the street, but they're considered to be on the street because the intention of the parliament was to remove prostitution from public spaces, right? So the courts focused on the mischief of the act that was aimed at tackling, and found a secondary meaning of the word solicitation, right? Which must take place in the streets, not the person necessarily be on the streets, thus making them liable under the act. So
there's this one mischief that they try to gap with this. Uh, okay, so the next would be East Borough Council 2000. It is illegal for a taxi driver to try and attract customers without license. The taxi driver was parked on private land, but it was close to the street where he could still get customers. He was seen as plying for hire. Okay, so exactly the same, literally the same point. And the point is that even if the taxi driver is in a private like land, he's in a private parking space, as were the women. They were inside like, a house, and they were tapping on the windows of the house, not even like coming onto the public walk. But it's held that they're trying to, apply for hire. So they're trying to get the customers from the public because they're near the public, because they're literally near the public. So that's what the intent is. I think I had one more case because I actually really liked this rule. So it was the Royal College of Nursing, right? This is a 1981, so this is not like 2000 in front. So this is 1981. The Abortion Act in 1967 provided that only a doctor could carry out an abortion, subject to the fulfillment of certain conditions, right? However, in the given case, nurses had been engaged in administrating abortion, right? Administering abortion. So the court decided that the modern medicine has allowed for different methods of abortion to be implemented, some of which could be administered by nurses. Therefore, a broader interpretation of the Abortion Act 1976. Um, okay, I don't remember if it was 67 or 76 because I genuinely don't. But yeah, but it was the Abortion Act. Okay. Um, so a broader interpretation was favored in this case, and the act was brought about at a time when there was like a large number of illegal abortions. So, see, the idea behind illegal abortion, one of the ideas behind illegal abortion is okay. So, one of the ideas behind illegal abortion is the fact that women are not given um, access to abortion. Like there, the case of Roe v. Wade, and these things are problematic for women, right? In general. So because of that, this was a good step, one may say, from the judge's side, that they interpreted it in a broader sense, which would give nurses, because there are different methods today. A nurse can administer a syringe, or I don't know how it works because I'm not a medical professional, but understanding by the knowledge that I have, it would be that they can administer pills, they can administer syringes. Now, not every single time a doctor has to be there, right? So in order to, do the abortion. So I guess that was a good interpretation of the statute, that okay, because now um, abortions can be carried out by the secondary medical profession, that is the nurses in this case. So, and also to ensure that the abortions were actually carried out by licensed and skilled medical professionals and practitioners, not just anybody um, on the street saying that, okay, do you want an illegal abortion because you can't get an abortion at the clinic because you don't, like, the doctor is not giving you time, or there are like 10,000 reasons. I don't know. You can't go to a like doctor tomorrow because like he's going off. I don't know. But like, at least with this, you have more people coming to the practice and recognized and a licensed, skilled medical professional rather than going for, I don't know, just another person on the street. So that was a good idea of using mischief approach, right? So there are advantages to it and disadvantages. So the advantages are it promotes the purpose of the law, of course, the parliament's intent, right, allows the judges to fix gap left by the parliament in statute. Because, of course, parliament cannot make such a descriptive statute, right? They can't. And they can't predict every single case that will come to the court. It's just not possible. And allows for just cases as well. So, yeah, not to lead to an absurdity, not to lead to a repugnancy. What are the disadvantages? Judges are making law. Mm, you know, question mark. Uncertainty in law, because every single case will be dealt on with the facts of the case. And I don't find it to be wrong. And I that's my, interpretation. That's my thought. You may agree with it, you may disagree with it. Now, the third is not as wide as purposive approach. Now, of course, we will be looking at purposive approach. Now, some may say this purposive approach has been taken by the teleological approach by the European Union. Now, again, not really going into that, but I'll just consider purposive approach. I've written a lot on purposive approach, but I'll just read it out, and I will not go into the European side of it at all. So this is similar to the mischief rule, which it is, right? A bit. However, here judges are taking a wider view and trying to ascertain what the purpose or goal of an act was when Parliament was enacting law. This is about the essence or spirit of the act. Okay, with this, there's also the practice paper and the idea that the judges can, look at what the parliament was actually discussing at the point during the discussion of the parliament. So that has been a bit controversial, and that has been discussed in the idea under practice paper and further. So now going through that, I'm just going through the approach, what it means and what it is, and with some case law here, right? So this was first propounded by Lord Denning. Of course it was, because you know I feel like he was very ahead of his time. If you like go through um, all like years of your law, you'll understand that that man, of course, he shook a lot of, he made waves, he shook a lot of people, but it was fun, I think. Understanding his point of view has been very, you know, enchanting, actually. It has been a very educational feat, I think. So in MAGA and okay, so yeah, Newsport Corporation, that's the name that's mostly used for this. So he says, we do not sit here to pull the language of Parliament to pieces and make nonsense of it. Not sense of it. We sit here to find out the intention of Parliament and carry it out. We do this better by filling in the gaps and making sense of the enactment than by opening it up to destructive analysis. Very true. So he rejected the statutory interpretations that relied on pulling the language of Parliament to pieces. Now, okay, so the pieces idea is, reading up, reading down, adding in, those ideas as well. Okay, so this is something that lawyers are prone to do. So this is the idea of, adding inward, deleting a word, reading up, reading down, all of that jazz, right? As judges, their role is to discover the intention of parliament and ministers, and this helps in filling the gaps. Very true, because even in mischief, there have been gaps left by the, intentionally, one may say, left by the parliament. So the judges have a more discretionary, approach there. So they can take it with their own thought process and, discretion. So, Lord Griffith in Pepper versus Hart, Pepper and Hart, 1993. The days have long passed when the courts adopt a strict constructionist view of interpretation. Now, the strict constructionist view of interpretation may be the literal interpretation, right? The literal rule, which requires them to adopt the literal meaning of the language. The courts now adopt a purposive approach, which seeks to give effect to the true purpose of legislation and are prepared to look at much extraneous material that bears on the background against which legislation was enacted. Now, this extra material, that is extraneous material that we talk about, is the while the ministers are in the parliament, what they were talking about. It's one of those things, right? And okay, the thing that I have highlighted and bolded over here are the strict, the literal view and the effect of the true purpose of legislation. It is not necessary for a student to, write the entire paragraph of what the judge said. It is, sometimes better that you take out the words that is like effect to the true purpose of legislation set by Lord Griffith in Pepper and Hearth. So you can say it that way as well, and it would, say, oh, the person knows what they're talking about, what case they're talking about, and how Lord Griffith, said that there needs to be a purposive approach. So you could maybe just write it from effect of the true purpose, or you could also say that now adopt a purposive approach, right? Which in order to which is giving effect to the true purpose of legislation, something along that line in your answer. So you know it shows that you've read the quote, it shows that you've read it, but it also not fills the half of the page with just words from a paragraph that are not, it's not exactly like a memory test, it's a test of how you pick, choose, and put it in your answers, how you put nuances in your answers, right? So the next thing is Pickstone and Freeman's. So the House of Lords held that it was necessary to read words into inadequate domestic legislation in order to give effect to European legislation. Ms. Pickstone was entitled to claim on the basis of work of equal value, even though there was a male employee doing the same work as her. Right? So this is okay. Just a bit. So this idea goes on the nuance that you need to be paid equally, right? And in this case, Miss Pickstone was entitled to claim like equal value for whatever work she was doing. Then we have in contemporary judicial practice, the pendulum has swung towards purposive methods of construction. Right, Lord Bingham in our Quentville, that's what I can say. Uh, Encouraged by the teleological approach. Now, this is the approach that, of the European community jurisprudence and the influence of European legal culture generally. Why do we actually? Why have I been saying it's by the European Union or the European Community jurisprudence? That's because um, understanding the fact that UK joined the European Union, and of course, things, they overlap. You read, you go through their work, have you have people from that place, you have certain influences from that place. So that those influences also bleed into your um, legal system and in interpretations. So here it says this change was not initiated by the logical approach of European community jurisprudence and the influence of European legal culture generally, but it has been accelerated by European ideas. So that's how, Lord Bingham puts it. So because, every other time anyone talked about, they were saying, oh, they're completely influenced by it. So what he's saying is, no, we're not influenced by it. We already had those influences. See, mischief is there since 1500s. So you're not really influenced. So you could argue otherwise that you're not really influenced by the European. If the question comes on, European legal, culture influencing the legal system of UK in statutory interpretations, you can argue in this idea that no, not exactly because we had mischief rule, but yes, one may can also say that you were accelerated by European ideas because of the EU merger. So legal principle established in this case that legislation can be interpreted using a purposive approach. Yeah, so that's what it is. Lord Bingham and Health. So this is Secretary of State of Health, 2003. The basic task of the court is to ascertain and give effect to the true meaning of what Parliament has said in the enactment to be construed. So Lord Bingham has been, that we are just giving meaning to the what our Parliament has said. So that's his stance. You can clearly see it. And in yeah, so I think I just have given it a wider here what the case was about. So this is purposive approach was used by the House of Lords, where Section 1, subsection 1 of the Human Fertilization and Embryology Act 1990 defines that a live human embryo where fertilization is complete. However, science advances and creation of embryos did not require fertilization. Cloning method was used now. House of Lords used the purposive approach for interpretation, and it was held that medical and scientific technology had advanced from the time the statute was enacted. Court had to interpret the statute with accordance to the advancements, right? While the general boundaries of purposive approach can be identified, there are too many subjective factors in play to say with great certainty whether or not any given statute will be interpreted narrowly or broadly. Now you have to go through a lot of different cases. Now the cases could be Bollinger or Books Finder Limited. Okay, I'll just talk about Bullinger actually here. So a case, Bullinger is 1974. Yeah, it was 1974. A case about use of the name of champagne. Lord Denning in this case, because of course, that's the case I'll take. Lord Denning signaled English courts would have to veer away from the traditional approach used in domestic legislation, as all member courts must interpret EU laws applying the same rules. The purposive approach is standard in civil law system like in the EU community. Now, this was an EU case as well, in a kind of a EU proposition, if you talk about that. So, the labeling of the name, the champagne, that, and then what other case can I talk about? um Okay. Oh, okay. I am missing out a very important idea in Pepper and Hart. The Pepper and Hart a tax exemption case. All right, this was actually a tax exemption case. I remember Lord Griffith talking about it, but this was actually a tax exemption case where dealing with the interpretation of Finance Act to find the context of what Parliament's intention were here. The House of Lords made the use of Hansard, the parliamentary debates report. That's what I was talking about. I wasn't remembering the name exactly. So the name is Hansard, and that's the extraneous that they talk about here. So this is the material that they're talking about is the Hansard, because it was used in Pepper and Hart. So this is a very very landmark case. So this is how they found what the intention of the parliaments, the ministers were while in the session. Moreover, we can also talk about the bookfinders case, the Revenue Commissioners 2020, right? So this is a very recent case. The intention of the Value Added Tax Act of 1972 was to make a distinction between um, bread as a staple food. In Ireland, staple foods like bread are exempt from the value added tax, right? The act gives a definition of bread, saying that the fat, sugar, and bread improver should not account for more than 2% of the weight of the flour in the product. So Subway rolls did not meet this definition because sugar amounts to like 10% of the weight of the flour. So yeah, so the court ruled against the bookfinders limited, right? So this is a very cool Subway case if you want to like read it out. I think it was a fun case. I remember now. I remember it. Um, about like 10% and 2% off. I remember not eating Subway for a very long time because of this. I was like, oh my god, there's 10% off like sugar in this flour. Anyway, so we understand that Lord Denning was one of the view that the approach that was allowed, that was the best for the judiciary to carry out was the purposive approach, and oh, there was still a point. So, however, on appeal of the same case, right? So Lord Simmons described the approach as a naked usurpation of the judicial function under the guise of interpretation. If a gap is disclosed, the remedy lies in an amending act. So he was saying, Lord Simmons were like, oh no, it's not the judge's, um, point or discretion to work on bridging the gap. It is for the parliament to work on this. So this shows how different judges see different purposes approach. So you've got that, and so the advantages of purposive approach are It is flexible approach. It is a flexible approach which allows judges to develop the law in line with Parliament's intent. So Mansell and Owens, you can read this case. It allows judges to cope with situations unforeseen by Parliament controversial. True. It allows the law to develop to cover advances in medical science. We've had that. Health, 2003. It allows the court to give effect to EU directives. Yes. Fixed on farmers, allows reference to Hansard, makes it easier for the courts to discover Parliament's intent. This is Pepper and Hart. And disadvantages of purposive approach as judges are given too much power to develop the law and usurping the power of Parliament. Um, Judges become lawmakers, infringing on the idea of separation of powers. This is the Montesquieu, the three limbs, you need to keep it separate, but now they are infringing on this idea. There is scope for judicial bias in deciding what Parliament intended, because of course every judge will see a Parliament's intention as different from their eyes. It is as you can literally talk about Lord Simmons and Lord Denning. Lord Simmons is like, no, we're not. In the same case, Lord Denning is saying that you need to use purposive approach. In the House of Lords, Lord Simmons is like, no, we're not going to use purposive approach because it's for the Parliament to amend the act. So it assumes that the Parliament had one intention and ignores the fact that the Parliament is divided on party lines. So again, it kind of means that okay, you can just in Parliament can intend one thing and the judges can intend the other thing, and we're going with whatever the judges are intending at this point. So that's the end of it, pretty much. And this is, of course, if a journal answer comes. Here, you will give your conclusion, where your ideas lie, how do you conclude it, what approach you think is better, and what approach you align with. So, this is as short as I could make it. Of course, I did not add a lot of case law, I added only literally specific case law, and I hope this helps. And these are a lot of pairs. Yes. Thank you for watching this video. I hope this helps. If there are any questions for your exam, just let me know in the comments and I will get back to you as soon as possible. And that is literally within an hour or so, I hope. Okay? Stay safe and best of luck for your papers. Bye.